Welcome everyone, and thank you for waiting. I'm Tim Jacob, Policy Associate at Swords to Plowshares, and your facilitator for today's webinar on Veterans and Criminal Justice, New Developments in California Law and Treatment. This webinar is organized by the Institute for Veteran Policy at Swords to Plowshares as part of our Veteran and Behavioral Health series. Veteran advocates, mental health care providers, and criminal justice professionals now recognize evidence that military service-related mental or cognitive injuries may contribute to criminality. As a result, a movement to treat rather than incarcerate veterans in eligible cases has emerged throughout the nation. California stands as a bellwether in this movement with a growing number of veteran treatment courts. In addition, the California legislature has expanded on criminal laws which provide alternative standards in sentencing for veterans with mental health trauma, and post-traumatic stress disorder is increasingly being used in criminal defense. This webinar will provide behavioral health providers, veteran legal advocates, and others with an understanding of the circumstances in which veterans can become justice involved, data on justice involvement, and California laws and treatment programs which affect veterans in criminal justice. 2 continuing education units are available for MFT, LPCC, LEP, and LCSW professionals licensed in California. During this webinar, you may type a question to the panelists or Swords to Plowshare staff at any time. Simply type your questions in the question box on the right side of this webinar's display. At the end of the presentation, we will review the questions and comments posted and generate a discussion. Please note, this webinar is being recorded and will be archived on the Swords to Plowshares YouTube channel. We will email you copies of the PowerPoint following the presentation and notify you when the webinar is archived and available to watch. Our first presenter, Megan Zottarelli, Senior Analyst at the Institute for Veteran Policy at Swords to Plowshares, will cover the circumstances by which veterans may become justice involved and the character of veterans in criminal justice. Scott Franklin, Public Defender, Sacramento County, will cover California legislation affecting veterans in criminal justice. And finally, Duncan McVicker, California Veterans Legal Task Force, will cover veteran treatment courts for eligible veterans. Our first panelist, Megan Zottarelli, Senior Analyst at Swords to Plowshares, manages the Institute for Veteran Policy's research and analysis of data and policy related to veterans and advocates for increased access to services and support. She is the author of Veterans and Criminal Justice, a review of the literature, which has been used in curriculum for attorneys as well as numerous curricula for the National Association of Social Workers and others. She has a long history working in mental health advocacy. Welcome, Megan.
Thank you, Tim, and thank you to our participants for joining us today. This is an important conversation, one that is gaining traction, and it deserves some conversation as there are new developments in California law and treatment for justice-involved veterans. But to start at the beginning of this conversation, we really need to understand the scope of the problem. And at the interface of the criminal justice and mental health systems is the justice-involved veteran with mental health or cognitive trauma stemming from their military service, whether from combat, non-combat, military sexual assault, or other service-related trauma that may have been connected to their criminality. So the question that many ask is, how do we carve out exceptions to the criminal law for these veterans, and in consideration of significant disadvantages or mitigating circumstances? How do we establish criminal responsibility and also take into account the circumstances by which they came to commit these crimes? So the movement to engage veterans with treatment over incarceration has 2 arguments, which I just really want to briefly summarize for you all. One, some say that veterans are a special population, deserving of treatment over incarceration because they serve their country, and it's our country's responsibility to take care of them. So while this sentiment is held by many, some veterans feel uncomfortable by this label, as they don't want to be classified as a special population, or they feel uncomfortable with such treatment. Other advocates, the non-veteran population with significant disadvantages or trauma, also have special needs that require tailored treatment. But the fact remains, veterans have unique issues within the scope of mental health in the justice system, and they require a tailored, specialized response. The other argument for treatment is, of course, that effective mental health and drug treatment intervention has been shown to decrease recidivism over the long term. So tailored treatment approaches allow individuals to reintegrate into society, lessening reliance on state-funded healthcare, public assistance, and law enforcement. The literature also shows that providing veterans an alternative process is likely to save the state money. So in the short term, diversionary programs cost less because there is a reduction in the number of offenders entering prison and parole supervision programs. And also, I just want to make note that placing a veteran offender in a diversion program in place of incarceration will have a significant impact on the veteran's status within the VA. So alternative sentencing allows veterans to continue receiving benefits and mental health substance abuse support that they rely on and they greatly need. Preventing the withdrawal of benefits as a result of incarceration allows for a smoother readjustment process after sentencing requirements are met by avoiding the complex and frustrating uphill battle of reinstating those benefits through the VA. So let's get into the data a little bit. Data are ultimately lacking on how many veterans are arrested, how many come before the traditional courts, or how many are incarcerated. The last national picture of veterans incarcerated in state and federal prisons was in 2004, and that was conducted by the Bureau of Justice Statistics. And that showed that approximately 10% of persons in state and federal prisons were veterans. And this is, as many advocates state, the data that got away. So the next Bureau of Justice Statistics survey was to be publicly released around this year. They have an 8-year data cycle, and then typically they'll publish the results 2 to 3 years later. But I'm not sure of when, in fact, it will be released. So we are to rely on this, outdated data for a national picture of justice-involved veterans. So what the data do show us is that historically, post-Vietnam, there was a wave of veterans represented in prisons, but those numbers decreased over the years. So in 2004, 10% of state prisoners reported prior service in the U.S. Armed Forces, and that was down from 12% in 97 and 20% in 1986, which was 11 years post-Vietnam. The 2004 data cycle was conducted when the wars in Iraq and Afghanistan had recently begun, so it doesn't give us a complete picture of the impact and the influx of current-era Iraq and Afghanistan veterans in the system. The data do show that veterans had shorter criminal records but longer sentences, and that they were at the time, half as likely to be held in prison, so they had lower incarceration rates, but were more likely to have violent offenses. They found that 57% of veterans in state prisons were serving time for violent offenses, with 22% doing time for drug-related offenses. So, and at the time, the majority served during a wartime period, but a much lower percentage reported seeing combat duty. And keep in mind, this is 2004, so it was just shortly after the wars in Iraq and Afghanistan had begun. Vietnam-era veterans were the most common wartime veterans in both state and federal prisons. And the average length of military service of veterans in prison was about 4 years. Interestingly, up to 40% received less than fully honorable types of discharges, including around 20% other than honorable, bad conduct, or dishonorable, which is fairly comparable to the general veteran population. And at the time, they were almost exclusively male. And as many of us know, it's extremely difficult to capture women veteran numbers, as they tend to self-identify even less than veteran men for various complex reasons. In terms of reentry, up to 56,000 veterans are released from state and federal prisons each year, and 90,000 from city and county jails. Note that this data presented here is through a sample of 1% of all state and federal prison inmates, and it was through self-disclosure, as the inmate was not required to report veteran status. So of the 12,000 or so total prison facilities, state and federal, they surveyed 254, and they didn't disclose the locations of each of those 254 surveyed facilities. So as some advocates have noted, these are likely largely underrepresented numbers. As I mentioned, they relied on self-disclosure, and in many states there may be facilities which take higher numbers of inmates who are veterans, such as California, Texas, and Florida, which have the highest numbers of veterans, and also facilities located around military bases. So in the absence of national data, local data provides a somewhat piecemeal picture of veterans in the justice system, and this has been done anecdotally throughout the nation, mostly through local jail populations, some state prison systems as well. This data done by California Veterans Legal Task Force this year is more comprehensive than most on veterans in county jails. Duncan McVicker, a fellow presenter, is part of the California Veterans Legal Task Force. And the county jails is, where veterans are more likely to benefit from the veteran treatment court model or other diversion programs. The percentages of veterans represented in the jails over the last few years in California vary by county, but the median is around 5.5%, which appears to be fairly consistent with other state county jail counts. So the research on Alameda County was conducted also by Duncan McVicker, and he held face-to-face interviews with 100 inmates of Alameda County in 2012. The purpose being to understand the characteristics of the veteran population in the criminal justice system of Alameda County with the aim to identify their special needs so that they may be addressed in a possible veteran treatment court. So it was really a needs assessment for the veteran treatment court model. And keep in mind that this county is heavily influenced by its urban geography, as Alameda County includes Oakland, and also that the survey results are skewed towards felony charges, since more than half of those with felony charges were in county jail due to parole violations. That was something that they learned throughout the interview process. But the data tell an important story nonetheless. So these veterans experience a higher level of mental health issues than the typical jail population. 3/4 report substance abuse, most of them alcohol, sometimes along with drugs. A large number report some other form of mental illness. Many have attempted or considered suicide, and I'm not sure of how many of these mental health issues that are cited were established to be service-connected, but perhaps Duncan can elaborate on this more. Interestingly, 11% received other than honorable discharges, and almost half of those whose charges would have been eligible for treatment diversion were given other than honorable discharges, which may bar them from VA services. Of course, if they have a service-connected disability, they can receive services for that service connection, but that's a difficult process to navigate. Jail pods. Jail pods are emerging in many states, including California, Florida, Texas, Illinois, Georgia, and Arizona, among others. Housing veterans in a common area of the jail allows the jails to streamline case management and also allows veterans to provide peer support to one another. And so typical of these jail pods, inmates receive intensive county and community provided classes. These classes can include substance abuse prevention, career planning, anger and stress management, and some even provide yoga, Zen meditation, and art therapy sessions. A huge component of these pods are the camaraderie that occurs through peer support, as these veterans are able to connect with one another and find strength through their common ties, whereas they would otherwise ultimately be isolated. It's an amazing form of rehabilitation and treatment for those ineligible or opting out of diversion programs to prepare them in the best possible way for reentry. What I don't know is the overall effectiveness in terms of recidivism of these pods. I do know that our personal work of having Swords to Plowshare staff specifically devoted to the Cover program in San Francisco, that there is a tremendous value in the pod in terms of creating that peer support, which is a crucial component of justice-involved veteran treatment. So in the Cover program in San Francisco, 25 veterans currently reside in the pod, which is a huge decrease from the previous years, since San Francisco Veterans Court has begun to process many of these veterans who would otherwise be incarcerated in Cover. So those who are in the jail pod have either been deemed ineligible for the veteran court or opted out of the court, typically. So in LA County, where the Sheriff's Department runs the largest jail system in the country, 291 prisoners are housed in veteran-only dorms, and they participate in programs including drug and alcohol classes, art classes, computer classes, and relationship counseling. San Diego County has Module 3, or as they call it, Veterans Moving Forward program, and that has about 32 veterans serving sentences or awaiting trial live in the module, although that number is likely to be higher now, since last I heard they have plans to build an additional module. There is also a large waiting list to get into the pod. San Diego County has a high number of veteran population, also a military base. And I don't have the eligibility points, but assume veterans must fit certain criteria aside from it being first come, first served to be admitted to the pod. So moving on to identifying veterans. Identifying veterans is a complex process. Identifying arrestees at booking is possible if they are asked the question and they choose to answer truthfully. Many counties rely on the arrestee's self-disclosure. Some choose not to disclose their veteran status at booking for various reasons, including fear of having their VA benefits stopped. Others may have other reasons, such as shame. When a veteran arrestee does disclose his or her veteran status, the typical response is that the booking staff or the jail's program staff notify the local Veterans Justice Outreach Coordinator at the VA. And the purpose of the Veterans Justice Outreach Program, the VJO program, is to avoid the unnecessary criminalization of mental illness and extended incarceration among veterans by ensuring that eligible justice-involved veterans have timely access to VA services. So they're responsible for direct outreach, assessment, case management for justice-involved veterans in local courts and jails, and they also liaison with local justice system partners. Duncan will go over their role a little bit more when he talks about treatment courts. The best possible outcome is that the VJO routes the veteran to treatment alternatives such as veteran treatment court or works with the public defender to apply diversionary law if available and if the veteran is eligible. The VJO coordinator will research the individual's background to determine eligibility for assistance, and they'll provide an assessment of those services when the offender is released. So the jail regularly sends the VJO coordinator a list of veterans known to be in the jail population, and the VJO coordinator comes into the jail to meet with them and do the assessment. The VJO coordinator locally in San Francisco liaisons a lot with our COVER program and sort of helps coordinate some of the classes that are offered in the jail pod. The VA has also implemented a database tracking system with many counties to match identity records at booking with those enrolled at VA. And as far as I know, and I don't have a lot of info on this, this works for those who are enrolled in VA services. So in the vein of justice involvement and mental health trauma, particularly post-traumatic stress disorder, it's important for forensic mental health professionals to have an understanding of the real interface of the criminal justice and mental health system. So at the heart of this interface, the veteran and forensic treatment interface, are the clinical concerns that are increasingly recognized, especially among current era Iraq and Afghanistan veterans. I'll address some of these before we move on to Scott and Duncan's portions, which cover some legislative and system-based responses to them. At the heart of the argument for treatment alternatives to incarceration is, of course, mental and cognitive injuries related to the veteran service. So it's important to recognize that the veterans may commit crimes for various reasons they're multifactorial, and these mental health considerations, they are potentially contributory. But establishing the nexus of the trauma to the crime can be controversial so it depends really on the context of the crime and the individual's service-related injuries. It's important as a mental health practitioner or a legal advocate to have knowledge of the related literature and an understanding of veteran issues in order to provide more informed assessments. So the data here tell an important story. This study was done this year on mental health concerns of justice-involved veterans, and it was across samples drawn from 1987 to 2013. So that includes both incarcerated and community samples. And the review included data supplied by the VA Veterans Justice Programs. The review highlights some very prominent mental health concerns among veterans. So many justice-involved veterans have likely experienced at least one traumatic event. Many have post-traumatic stress disorder. Across the samples, there was prevalence as low as 4% and as high as 39%. At least half of justice-involved veterans have an alcohol or drug use disorder, with estimates as high as 71 and 65%, which is a huge proportion of the sample. Justice-involved veterans with comorbid substance use and psychiatric disorders, they're at an increased risk of negative outcomes, they found, including homelessness and violent behavior. So ultimately, this data shows that compared with other veterans, justice-involved veterans have consistently higher rates of mental health concerns, particularly substance use disorders. So this study, which was done by the Healthcare for Reentry Veterans program at the VA, which provides outreach services to veterans incarcerated in state and federal prisons, compared the risk of incarceration of veterans of Operations Enduring Freedom, Iraqi Freedom, and New Dawn, and to identify socio-demographic and clinical characteristics of incarcerated veterans from those current era veteran populations. So regardless of ethnicity or age, OEF, OIF, and OND veterans were less than half as likely than other veterans to be incarcerated, interestingly, and constituted only 4% of the incarcerated veterans. Compared with other incarcerated veterans, Iraq and Afghanistan veterans were more likely to report combat exposure and were 3 times more likely to have combat-related post-traumatic stress disorder. But also interestingly, they were 26% less likely to have a diagnosis of drug abuse or dependence. So while they appear to be at lower risk of incarceration than veterans of other service areas, those who were incarcerated had higher rates of PTSD. And so the reason why I highlighted these studies is that really in the absence of national data provided by the Bureau of Justice Statistics, really we need to start looking at VA and other data that can tell more of a national picture. One important thing to mention about prior era veterans, I'm speaking anecdotally here. There are other studies that prove this as well. Many prior era veterans are casualties of the streets and of the justice system. These are populations that we see at Swords to Plowshares as often socially isolated as compared to current era veterans, which for veterans is the greatest predictor for both mental health issues and homelessness. So prior era veterans are overwhelmingly represented in both the veteran homeless population and in prisons. For veterans who lack access to care for psychological conditions or economic support, their lives can quickly unravel into a cycle of poverty and of homelessness. Many of these veterans give up on the system and they take matters into their own hands, and through criminal acts, it's through drug use, theft, and property crimes. And these veterans are engaging in illegal survival tactics, and that of course makes them prone to arrest and conviction. Many of them, also homeless, would rather spend a night in jail than on the streets as well. The BJS data from 2004 confirms that older veterans are overrepresented in prisons, with differences in incarceration rates among veterans and non-veterans driven heavily by age. So in 2004, 65% of veteran males were 55 or older, compared to 17% of non-veteran men. So while this number likely changed with Iraq and Afghanistan veterans influxing into the state and federal prison system, the fact remains that veterans age 55 and over represent 66% of the veteran population in the U.S. and 22% are over 75 years old. So this is a population that we still, of course, need to deal with and think about in our approach to care. So a huge problem among justice-involved veterans is substance use, as I've noted in some of the previous cited studies. More than 1/2 of U.S. military veterans with criminal justice involvement report problematic substance use, but less than 1/3 ever receive or engage in treatment for substance use disorders. And this study showed that many of them had access to the Veterans Health Administration, but yet they still did not seek or receive or engage in treatment for substance use disorders. And that study was done by Glenn and colleagues last year. The data show that the single greatest predictive factor for the incarceration of veterans is substance abuse. Substance abuse and dependence often becomes a primary means of self-medicating for underlying untreated mental health issues. As one study I mentioned stated, comorbid substance abuse and psychiatric disorders are at an increased risk of homelessness and of violent behavior. So justice-involved veterans and violence, it's often the elephant in the room. It's a touchy subject since, of course, not all veterans have mental health trauma, and of course, there's the mislabeling that veterans with mental health trauma are violent. So let me preface this by saying that while this is a small subset of the veteran population, this may also be the most critical to address, yet violent crimes are often omitted from criminal justice treatment programs. So while diversion programs may not always be the most appropriate avenue for the violent offender, and I'm not saying that they are, we must examine how best to rehabilitate violent offenders, since if they are not addressed in the front-end treatment sphere, we may not be reaching the most critical population of offenders. When looking at aggression, researchers have found that there are many different types of aggressiveness related to different factors among veterans. So there's problems managing anger linked to relationships, aggressive impulses and urges linked to mental health, and also family mental health. There's problems controlling violence linked to violence exposure, so witnessing violence or actively participating in violence. And not all veteran families, of course, experience domestic and inter-partner violence, but the trauma of war and military service can easily come home. So the reasons may be a complex set of circumstances, including mental and cognitive trauma, and also economic factors after transitioning out of the military, which can create a recipe for the violence. But the exact nexus between the root cause and the violence may or may not be directly linked to military service-related trauma. But among those with severe, or among those with post-traumatic stress disorder, there's a significant link between the severity of the PTSD and domestic violence and IPV severity. So while traumatic brain injury and domestic violence and interpartner violence hasn't been as widely researched, there is symptomology of both PTSD and TBI, including impulsivity, aggressiveness that may contribute to relationship strain, and ultimately violence if there is not an intervention. Some substance abuse is known to intersect with interpartner violence. And individual interpartner violence cases may show a connection between the violence perpetration and the PTSD or the TBI, as I stated, but those cases are often omitted from criminal justice treatment programs. And when not excluded, they're typically examined on a case-by-case basis to determine the nexus. So my last slide, really suicide is the ultimate fallout of justice-involved veterans. Wurtzel and colleagues, they stated that incarcerated veterans are at a greater risk than the veteran population, the general veteran population, for committing suicide due to a combination of risk factors, which include the frequency with which veterans are incarcerated for, as they stated, seemingly impulsive and violent crimes, and the frequency with which they are involved in traumatic events. Incarcerated veterans have been shown to have the highest risk of suicide among all veteran populations, and that was cited before the VA's Veteran Justice Outreach Program and Healthcare for Reentry programs really began and got off their feet. And also important, the numbers show that suicide among veterans outside of VA care is increasing, while suicides among those receiving VA services is decreasing. So this is an important consideration. Research has also shown that VA benefits appear to offer a protective effect against deaths after reentry. There was another really good article that said, don't wait for the numbers of suicides among incarcerated veterans to be confirmed. We must do more prevention and critical intervention with those expressing risk. The VA's justice programs are doing critical work in this by assessing incarcerated veterans for reentry, and really clinical interventions must be made in order to address this problem. This is, as I said, the ultimate fallout. With that, I thank you for your attendance, and we'll be happy to answer any questions you may have during the Q&A, and I'll turn it over to the moderator.
Thank you, Megan. Our next panelist is Scott Franklin, Sacramento County Public Defender for the past 11 years. During the last 4 years, Scott has assisted in creating the Sacramento County Veterans Treatment Court, and he has been active in assisting the homeless veteran community in legal matters. Scott has testified before the California Senate Veteran Affairs Committee, educating the legislature on veteran treatment courts and veterans diversion. Scott serves on the Governor's Interagency Council on Veterans Legal Task Force. Welcome, Scott.
Thank you. As I said, my name is Scott Franklin. I'm a public defender. I've been doing that work as a public defender for about 13 years now. I got into being a public defender in large part because I have a father who is a disabled veteran from Vietnam. And it was experiences with him and working with the homeless Vietnam era community that caused me to be involved in social justice issues and got me interested specifically in the law, dealing with our homeless Vietnam era veterans in our process through stand down. and we began working and volunteering together to do that program. It was a good bonding experience between the two of us, but it also led to an awareness of that issue that now I've been able to take into my practice as a public defender. What I want to talk about most from the last section is that veterans don't self-identify very easily, but it's often easy to identify them if you know what you're looking for. And I want to begin with that's the problem we've been having. We have statutes available to help them, but we have not been able to easily identify them. So the courts and the legislature have made some efforts to do that, and in part it has to begin where a person in the criminal justice system begins. We have to have an understanding that the first thing that happens for a justice-involved veteran that begins the criminal case is arraignment. That's the process in which they are told the nature of the charges, whether it be a felony or a misdemeanor, and whether or not they're going to hire a private attorney or get the assistance of a public defender. This is the first time that they're standing in front of a judge, getting told what the charges are, getting asked questions, and getting an opportunity to say something about what's going on. Now, thanks to new code sections that came into play this January 1st, we are actually having special provisions of law for veterans and active duty personnel being told and read to them. And what that comes to and what that purpose was is to do that early detection of veterans, because as you well know clinically, that sometimes that moment of crisis is the exact right time to engage in treatment. There are plenty of times when a veteran who has been in a state of denial for a long period of time, who is now standing in front of a judge and being told, hey, you've got some problems, you need to address them, will finally first engaging in, okay, I realize that right now it's my best interest to engage in treatment, and then we can lead them down that path. The purpose of Form Mill 100 and Penal Code Section 858 was to address this early detection. So I want to begin with how they begin, even though it's reasonably the newest of the statutes, what we're going to do. And this is what Form Mill 100 looks like in a court document, but in the long run, this part doesn't matter. This is just simply a way to notify, because not every county is as astute as San Francisco right now, and for many of the small counties, it's basically impossible to be able to get the information to the Veterans Justice Outreach Specialist at the VA from the Sheriff's Department. It's actually quite hard, and unfortunately there's some resistance in that regard between that kind of level of communication. Even our own sheriff here in Sacramento has worries about exchanging information to an outside source and opening themselves up to civil liability. The courts kind of got around that by having this form that allows a person at arraignment to fill out, sign, and then this form is then sent to the local county veteran service officer to be able to prove that this person is in fact a veteran of our armed forces of any kind. And that allows a response returned back to the court. The court can now consider that fact. Why is that important? Well, we know statistically that a veteran is much more likely to be coming back to court than a non-veteran. Veterans follow orders, including court orders, to come back to court. So it is actually a factor in that person's favor at a bail hearing to whether or not they are or are not a veteran. So it's important and imperative to get this particular notification back, have the court be able to rely on that form of information in some way that I could be standing in front of a judge saying, Your Honor, you have proof in front of you that my client is a veteran of the armed forces. We know that means he can follow your order. Give him an order to come back and he will do exactly that. So that can help us in that regard. But what it also helps is this second page. This second page is the part where it first notifies a veteran why it's important that we know that they're a veteran and that we be able to start a conversation with them about what have maybe happened during their service and to see whether or not it could apply for any of these statutes. And these are the three statutes we'll go through in a minute. that could apply in their case that could help them out in seeking treatment instead of incarceration. And don't bother reading this because I've got them separated out here in the next set of slides. So now we know that you are in fact a veteran, and we now have these three special provisions. The first one is 1170.9, which is the one that's the restorative relief and alternative sentencing. It's also the one that most courts use to provide and create veterans treatment courts. And those courts have basically come up in order to use this statute. Next is this Veterans Diversion Law, which is a brand new law that specifically targets misdemeanor crimes. And it has some new provisions that most counties are still trying to figure out how to make it work, but it's got an opportunity to do some of the same things, the restorative relief, but it's also got the opportunity to potentially expunge a person's record early on in the game, and can really help out our active duty folks as well. And lastly, is I call it the last line of defense, which is this sentencing mitigation law that specifically says the same factors can be used at that last moment when the judge is making a decision about whether or not to give a person probation or send them to prison or send them to an upper term, a middle term, or a lower term, one of the sentencing decisions the judge has to make. He is required to balance the mitigation factors versus the aggravation factors, and it's good to have more mitigation factors than it is aggravation if you're going to try to get your client the least amount of prison time or try to keep him out of prison and in our local jail system. So let's begin with the granddaddy of them all, which is 1170.9. This is the oldest of these statutes, and it's been changed and modified a number of times in order to try to implement changes to include a greater number of people. In the beginning, it was really designed for only combat veterans, and it come around that they started realizing that they were missing out on a number of people that weren't quote-unquote true combat veterans because of a narrow reading of that word combat. And so then it gets extended to have some greater powers and greater catch-all to people. What I want to begin with is what those rights are that a defendant is advised of. And I have them listed here, but I want to highlight just one or two of them. And that is that better chance of receiving probation. That's a huge factor when we're talking about granting a person a prison sentence or not, and having the opportunity to satisfy probation early can make a big difference. But this last one, the restoring rights and dismissing penalties and setting aside certain convictions, this is the real enticement in these cases. And it's nice that those things are there. Just give me a minute, I have to erase the drawings. Because that's the real best part. The requirements of the statute are also listed in it, and they're listed very simply. It's not enough to simply say these. So while the slides are here to include that language, we're going to discuss them more. But again, there's the same idea of compliance with the terms of probation is the thought. We put you on probation, you do it, and then you're going to get that relief. So in order to qualify for 1170.9, a participant must suffer from military-based sexual trauma, traumatic brain injury, post-traumatic stress disorder, substance abuse, or mental health problems stemming from their service in the United States military. That's the code section's direct words. That has been interpreted by every court to mean different things under some circumstances. But really what it comes down to is the crime must have a nexus. Because there's a connection requirement, that the crime must also have been committed as a result of that service-related problem. That means that we have to be able to say that whatever is making you currently messed up or currently symptomatic is a response to something that occurred to you during the military. And that traumatic condition has now affected your criminality. And everybody can make an argument as to whether or not it has to be the most important factor, one of the least important factor, could have been the factor that pushed it over the edge, and that's the area of interpretation, unfortunately, that I think leads to some differences between the counties. Right now, in Sacramento County, we have a belief that if it is simply a factor in it, then it's good enough. It doesn't have to be the only factor. It can just be a substantial factor. When a person is then placed on 1170.9, everybody has agreed that they are eligible and that nexus is made, that a participant is placed on probation. And during that time, they agree to suspend the incarceration period of time, typically, while they undergo treatment. It's also important that in order to make a decision to do that suspension, the court has to make a determination that the nexus is there. And that's easy when all parties can agree to it, but it also can be an area of litigation if the parties cannot agree on that. Once the participant begins treatment, it can last for up to the amount of jail time or prison time suspended. That can be anywhere from a year to 3 years on a felony, or it could be as little as 1 year on a misdemeanor or 6 months on a misdemeanor. Every court seems to have a thought that that might not be enough time, so some try to extend the length of time, and we have to remind them that there is statutory maximums in here. They remind us then that a client who is placed on probation technically has the 3 years or more of prison time suspended, and that could also be considered as part of that time frame. Typically, our court lasts between 12 and 18 months because that's kind of a median number that we use, and it fits a treatment model that we're used to. So that once that person then begins the treatment program, it's supposed to and specifically come from to deal with what the heart of their issue was. Whatever that reason why they're in the court and committing the crime has to be dealt with. And that treatment can come from any source. And the statute provides it can come from the VA, it can come from community-based programs, and from nonprofits. And honestly, it works best when it comes from some variety of all of that. Within our Veterans Treatment Court, we typically try to avail our clients of as many different sources of treatment as possible, because the more things we have available to persons, the more likely one of those is going to connect. So what can the participant get out of the statute? Well, and what are those incentives to participating in this kind of process? Instead of going through incarceration, of course, they can have that time either suspended, all of it, or sometimes only part of it. They can get their probation terminated early. They can have their probation requirements deemed satisfied, including the requirements of certain classes or programs that are mandated by the state that we can present an alternative to, and a judge can say that alternative satisfies those requirements because I'm deeming all of their requirements satisfied. This also can lead to reducing of charges from felonies to misdemeanors. We call this an expungement on steroids because this expungement is so good that it allows a person to sign on a penalty of perjury that they are not convicted of a crime, even though they've been convicted of a crime, been placed on probation for it. They are able to sign on any document except for in an application to work in law enforcement that they have never been convicted of a crime. This is a huge power for everybody to be able to that participates in this in order to be able to gain and seek lawful and good employment or housing, because it's a expungement better than anything else they're going to get. It's better than the simple regular 1203.4 expungement that most people can get, which hides the charges only from some people. This one is even better, and that's why we call it an expungement on steroids. What they do not get back, and this is a hang-up for many of our veterans, is they don't get their gun rights back. So if they've been convicted of a felony and part of this, they do not get their gun rights back. And it is still usable as a prior in some instances, most likely in a DUI and in a domestic violence situation, but also in an auto theft and a few others that have priors that would enhance or increase the punishment of any future crime of the same type. So it does not get rid of it for that purpose. That can still be used. And what I want to make sure everybody understands is that 1170.9 is usable at the time when you're making the deal with the judge to go through and do this, or alternatively, if you were a Vietnam era veteran who picked up cases in the 80s, sought treatment at the late 80s and 90s, and it has been well for the last 10, 15 years, and that they have not reoffended, their symptomology is managed or anything else like that, it is still possible to go back and use these statutes to go back and clean an old record. So some of you may have clients that may have that scenario. Well, they should start looking to seeing if whether or not one of these petitions could be done to assist them. So I like to end each section with what does it mean for you as a clinician. It means that you may be asked to do clinical evaluations, to be able to help prove or establish that nexus. It means that you may be asked to help provide a treatment plan or update a treatment plan along the way. It means that you may be required to tell a court whether or not a person is being successful in their treatment, and that's a hard word because that's the requirements of law, that they've successfully participated in treatment. That's a tough connotation. When some clients, that means achieving baseline that is satisfactory. To others, it's going to be able to get their symptoms to be lessened. And others, it's going to be almost or a full recovery of a lifetime. So successful, I think, is one of those individual determinations. But of course, having a clinician who can say, look, this is how far they've come from where they were to where they are now, can definitely help explain how they've benefited from treatment. This is the hardest part, I think, for any clinician, is that court also has to make a finding that the person does not represent a danger to the health and safety of others. And that kind of risk assessment is always a tough clinical decision. It's a tough decision for the court as well. So input in this regard could be beneficial, but it isn't always determinative. And I think it's sometimes tough, of course, to ask clinicians to say, hey, this person's never going to be a danger ever again, right? I doubt anybody could honestly say that. Next is the Veterans Diversion Law. In Veterans Diversion Law, this only applies to misdemeanor cases. It was originally intended to go to both misdemeanors and felonies, but it was kind of a legislative decision, I think, to try it out with misdemeanors. This is a pre-trial diversion program that does not require conviction, does not require being placed on probation, and does not tip for incarceration. If there's any incarceration, it must be done, at that point in early time when they may have, but before arraignment and before bail hearing, those kinds of things. It leads to a full dismissal of the charges. It can allow the arrest to have almost to seem as if it had never occurred, which is a pretty powerful. These are the in these special provisions of law, the requirements must include that it is only a misdemeanor, that they consent to diversion, that they waive their speedy trial right, and that they satisfactorily perform the program. That's it. Simpler requirements, but it also is much more ambiguous or open as to what it requires and what it means. Again, it has the same requirements. In fact, it's the same wording, that they must have that same military sexual trauma, traumatic brain injury, post-traumatic stress disorder, substance abuse, or other mental health stemming from their service. What it does not have is the double nexus. It does not require that the traumatic condition have any relation to the crime. And this could lead to somebody who maybe has a crime, has PTSD, but is also stealing people's identities to do theft, which really doesn't have much connection to PTSD and would be hard to try to make that connection. It seems to suggest that that element of the nexus is not required. It doesn't say it in the statute, but it does in practicality still have some requirements, which we're going to get to when we go over the code sections. This participant is not placed on probation. They'll never have a PO to check in with unless this is being done by probation doing their pretrial services workups. But they must willingly and accept participation in the treatment, and typically that means coming to court and saying, yes, Your Honor, I agree to the terms and conditions of this, or in some places signing a contract that says they agree to doing that same thing. The court, again, has the same requirements and duties to make a determination as to whether or not that pre-existing condition exists, and in order to do that, they may seek out clinicians to assist them in determining whether the criteria is met, whether the person does in fact have post-traumatic stress disorder, and does it stem from their military service. The statute allows for treatment up to 2 years and no appearance greater than 6 months apart. Typically that means that a court could begin the process and then have them check in a couple of times. A lot of courts don't want to have too many review dates if they can avoid it, just because most of the courts that are doing this kind of misdemeanor work would have a high volume of cases, most cases like this, and courts that run misdemeanors have a lot of misdemeanors. So they have to deal with a number of cases, and they like easy proof dates where people show up and have a letter from a clinician saying they're doing their work, they are satisfying their requirements, and they can move on and say, good summary, good report, come back in 3 months, come back in 6 months, come back with another letter just like this, and we can talk about when you could be done with this program. Again, the statute has the same language about the treatment can come from the VA or other community programs and nonprofits. So what does this mean for you? If you're a clinician, you may be asked to do clinical evaluations to help establish that diagnosis about whether or not the person has the existing condition, provide a treatment plan, update that treatment plan, and you may also be required to give those interim report dates, because unlike the requirements of 1170.9, and when you're talking about the military diversion law, oftentimes it's the judge who's still seeing those reports instead of it going through probation or through a VJO that might do case managing through the VA. It's going straight to the judge, and so oftentimes a report is necessary, or a letter to the judge telling them where they're at in their treatment. Are they participating? Are they going to their classes? Are they going to their appointments or not? Last, the court has to make a determination, did they significantly benefit from the treatment? That again is another hard thing for a court to quantify, unless you can talk about how much that person has gotten out of the program. And it's easiest when you can say, when they came in, they were low functioning at this, they were having problems with this, and now we've been able to see this strides and this development or growth. So the last line of defense is what I call this, because it's really the all else things have failed, and or your crime is too bad and no one's willing to help you out, really, is this sentencing mitigation law, which is 1170.91. And that one just creates its own mitigating factor for that same requirement of law that they have PTSD or MST or TBI. It means it's a factor of mitigation, but it's given a little bit stronger wording than other factors in mitigation, suggesting that it should be, if it's present, a reason for a court to give a person probation over prison. So this is good for two things. It's good for a tough decision when a judge has to make a hard, do I send this guy to prison or do I keep this guy locally, where we can keep some level of supervision about it. So it's specifically designed to say, judge, rule in favor of giving him probation. Don't send this man to prison if we can do better. And I want to talk a little bit about how that intersections with the new realignment statutes. We have these realignment statutes that have made less persons go to state prison in California, and more people are going to county jail prison. And the greater problem becomes that with that is then if you're going to county jail prison, the level of supervision you may have after isn't like it was on parole. So courts are sometimes uncomfortable with putting a person to county jail prison when they could give them probation instead. And that could typically mean less jail time, but better supervision. And this is a population who does better with less jail time. We know that doesn't really treat anybody that well. But with supervision, and certainly somebody interested in their outcomes, this group of people, this population, does pretty well. So when we have an extra little piece to throw at the judge to say, look, there's even this one little code section that really supports the defense, it helps us in that regard. I like to leave you where this kind of began, and this is a photo, and it's also a good transition to our next presenter. This is a photo of the Veterans Treatment Court in Buffalo, New York, and a veteran standing at ease or at parade rest in front of the Veterans Treatment Court judge that started the movement of Veterans Treatment Courts. I think nationally helped to push this concept. And what I want to kind of get through is that all of these statutes, they exist, they can be helpful. They're kind of unwieldy. They're not easy for a regular court to use. So what they have done is when these statutes are on the books, counties, states, places have created Veterans Treatment Courts to use these statutes in a way that lets them actually do the work that we're talking about in here and monitor to make sure that the person is doing the work. We describe it as a unique level of supervision. When you're standing in front of a judge, like this gentleman is here, and having to say, I've done what I'm supposed to do, judge. I've got a letter from my clinician. I've got a proof of my attendance at my community service, and I got a proof of my attendance at my DUI class. And you're standing in front of a judge, and he says, wow, 3 for 3, that's great. I'm proud of you. You can see these gentlemen standing at a parade rest crack a smile that is one of the awesomest things for a defense attorney to ever see. A client actually feel like they're getting something useful out of court. And that's what Veterans Treatment Courts have started to do. And it's a natural progression to say, Duncan, take her home from here and talk about how great this movement for Veterans Treatment Court is. Thank you very much for your time.
Thank you, Scott. Our final panelist is Duncan McVicker from California Veterans Legal Task Force. Duncan spends most of his time working with the task force to establish veterans treatment courts throughout Northern California. Duncan works nationally to promote diversion and alternative sentencing for veterans, seeking formal recognition of the value of treatment over incarceration for traumatized veterans accused of a crime. Duncan holds degrees from the U.S. Military Academy at West Point and from UC Berkeley. He served in Vietnam as a captain in the Army Engineers. Welcome, Duncan.
Thank you very much, Tim. So I'm going to pick up where Scott left off and talk about veterans treatment courts as they are implemented in California. This slide here shows that since 7 years ago when these courts were begun, the one in Buffalo, New York that Scott had a picture of was the first one. There have been over 300 created by now, and as I'll say later on, 24 of them in California. This map here shows the first 50 or so. So why is a veterans treatment court needed? And the answer is, it's all about mental health. Here's the thinking. Soldiers return from combat traumatized. We've heard today a lot about post-traumatic stress disorder. There's also a terrible injury, traumatic brain injury, that's characteristic, unfortunately, of the veterans of the current era. A lot of veterans return from their service with severe depression. All these folks need mental health therapy in order to put their lives back together again. But unfortunately, veterans often deny these problems. In fact, that's kind of a symptom of PTSD, is to be in denial about it. And if these problems are untreated, they'll actually get worse and sometimes can lead to crime. The Veterans Treatment Court is the mechanism by which we can help these veterans turn their lives around instead of merely throwing them away by throwing them in jail. And we do that by addressing the underlying mental health issue. Now, an issue that Scott brought up very clearly was we have to face the fact that participation in these courts is voluntary, so incentives are needed. And Scott talked about that in the way of the law, and I'll be talking about that myself as well. I thought you might like to see, before we begin here, typical offenses of veterans in a Veterans Treatment Court. One is anything that's high risk. A lot of these veterans, I'm talking about the younger ones of today for the most part, they've had this huge adrenaline rush, having been deployed several times probably in these combat zones. And when they come back home, things are just too bloody quiet. And they sometimes seek bad behavior in order to get that adrenaline rush. You know, driving 100 miles an hour down Interstate 5. I've even known veterans who actually committed armed robberies to get the adrenaline rush, not because they needed whatever it is that they were trying to steal. DUI is quite common because of the prevalence among troubled veterans to self-medicate, with alcohol being their medication of choice. But unfortunately, drugs are used a lot too, and that's why you see drug possession on this list. Probably the most common kind of offense you'll find in veterans treatment courts across the country is some kind of variation on a bar fight. You know, this guy is in a bar with his friends having a drink, and somebody insults the Marines, and the next thing you know, they're all in county jail. This kind of thing will happen among veterans, of course. More seriously, veterans are paranoid about their own security, having returned from combat. They still continue to sleep with their weapons. They carry them around even though they may not be legally entitled to do so. And that's a huge public safety problem, in that these guys have mental health problems as well as having these weapons that maybe they are not allowed to have. Domestic violence I would hope would not be on this list, but it is. It used to be that domestic violence among military families was lower than the general population, and that has changed in the last 10 years of combat, and now it's high on the list. A little talk I give to teams who are considering what kind of a veterans treatment court to create is, I tell them, if you really want to serve the veterans of today who are coming back and have these combat episodes fresh in their minds, the three things you're going to have to cover are DUI, domestic violence, and firearms. Here's the mission of a veterans treatment court. This is my favorite one. This is a mission statement written by the pilot court that was created years ago in San Diego. Note the last phrase there, unique mental health conditions stemming from military service. That is really what it's all about. You can think of three main goals of a veterans treatment court. The first is to reduce further criminal behavior, because after all, public safety is our chief concern in the criminal justice system. I'll be talking about this reduction of criminal behavior in the way of recidivism later on. Secondly, keep troubled veterans out of jail. Now, why do we want to do that? First of all, if veterans can live with their family, it is well known that they will respond far better to treatment for their mental health issues. They can also have jobs, bringing an income into their family, and therefore you don't have an indigent family in the community. And finally, they can receive VA benefits. You may not know this, but generally speaking, and there are some kinds of exceptions, a veteran cannot receive VA benefits while incarcerated. They have to wait until you get back out again. The third goal is to help these troubled veterans turn their lives around, which is kind of the bottom line of the Veterans Treatment Court. And we do that by getting them the therapy and other assistance they need. And therefore, they can become productive members of society instead of being those members of society that are causing a drain on society with their criminal behavior. The people that go around the country training about veterans treatment courts, that is an organization called Justice for Vets, part of the National Association of Drug Court Professionals, have a list of 10 key attributes to veterans, and I boiled that down to 5 for this purpose here. First of all, a veterans treatment court is a collaborative model of justice, as opposed to looking at issues of guilt or innocence. Instead, the judge surrounds himself with a team of professionals, and they work toward solving the problems that this person has. The idea of guilt or innocence is just well decided well before a person even walks into the veterans treatment court room. You can think of it as a hybrid of a drug court or mental health court. I prefer to think of it mostly as a special kind of mental health court because individualized treatment plans are created for each veteran, much like in a mental health court, whereas in drug courts, typically they're not so much individualized, but rather people are placed in categories and sent to programs. A second key attribute is to provide treatment in lieu of jail or prison. This is kind of the center, of course, of the alternative sentencing statute that Scott described. And that monitoring will typically go on for 12 to 18 months. Another attribute is integrated alcohol and drug treatment. A very large percentage, the study I did in Alameda County showed it would be 80%, I've heard numbers of 90% of veterans going through these courts will suffer from both addiction to a substance and some other kind of mental health problem that has contributed to this criminal behavior. And so you need to do frequent and random drug testing for veterans who are in these courts in order to be doing the best job of keeping track on how well they're doing. A fourth attribute is you ought to have a graduated system of incentives and sanctions in order to guide that veteran along the way as they're working their way through this 12 to 18 months of supervision. Incentives can be as simple as a compliment from the bench. It can be a Starbucks card or something like that. Sanctions, of course, can be a greater frequency of court appearances. It can be throwing somebody in jail for a few days to think about it, things of that nature. Many veterans treatment courts use phases, which is a huge incentive going into the next phase. You don't have to appear at court as frequently. Your probation appointments will be spaced further apart, etc. The fifth attribute I'd like to mention is peer mentoring. A key characteristic and different from any other kind of court that I know of is that in a veterans treatment court, every veteran participant in a well-run court, that is paired up with a volunteer mentor from the outside who walks through that 12 to 18 months next to the veteran. And boy, do these mentors ensure cooperation of the participants. Veterans can be a kind of a feisty bunch, but you put that veteran in relationship with another veteran who's walking next to him, and suddenly things get calmer and clearer. I don't know how many times I've seen some troubled veteran about to walk out of that courtroom really upset about what has happened to him, and the mentor's got his hand on his shoulder talking to him about, I know what it's like, fella, I've been there. Peer mentoring programs, I can't say enough about them, and I think they are a reason for the very low, that is, recidivism rates of veterans treatment courts. Speaking of recidivism rates, you can think of three big benefits to society of veterans treatment courts. The biggest one is probably lower recidivism rates. In California, we measure 2-year recidivism rates. That might change, but at any rate, here are the rates you can see that we're seeing in veterans treatment courts versus in the general population of courts. Among misdemeanors, veterans treatment courts are reporting, and this is not only California, around the country, numbers that range as low as 0 and as high as maybe 15%. That compares in California to 40 to 50% for misdemeanors. And look at the felony number. In California, recidivism rates of felons are 70%. That means once a felon has completed a sentence in the state of California, the odds are 70% that that felon is going to recommit another crime within the next 2 years. That's just amazingly high. However, in the veterans treatment courts, those numbers are less than 15%. That 15 number, by the way, is round. The biggest number I've ever heard comes from Santa Clara County here in Northern California, where Judge Stephen Manley runs the largest veterans treatment court in the country, and he reports a 13% recidivism rate. Now he's going on 8 years later. I must say that this is not statistically significant data. It's only initial anecdotal data so far, and we're working as hard as we can to get some real data for you. A second benefit is lower cost of incarceration. If you can get that veteran out of jail sooner than the veteran would otherwise, you're saving at the rate of $50,000 per year. If you go through the math, it's pretty easy. Even if the county had to pay for the supervision and the therapy costs, it would still cost less than $50,000 a year. So the taxpayers are getting a considerable benefit out of this. And then look at this third bullet here. Local taxpayers actually aren't spending much money at all on veterans treatment courts in the way of salaries or anything else, because the VA is providing almost all the therapy in these courts, and to the local taxpayers that looks to be free. I thought you'd like to see some data here from the San Diego, that pilot program I mentioned. They created a report following their first 3 years of operation, and then this pilot program shut down and they started a different veterans treatment court. You can see they had 74 participants go through their program during that 3 years of time. They had, by the end of the 3 years, they had graduated 27. 37 were still in the program. 3 had withdrawn voluntarily out of that 74, and about 7 had been kicked out of the program for one reason or another. And I find that to be kind of typical. About 1 out of 10 veterans will screw it up badly enough that the judge and the team will lose patience and kick them out of the program. Interestingly, too, the San Diego Pilot Court measured internal rates of recidivism, and that was 4%. That means only 4% of the 74, I guess that would be 3 of their participants, had another offense while under supervision during that 3-year period, and that's a pretty low number. And I'm not sure if that's typical or not. We don't have data from other counties about that. There are 24 courts operating in the state of California right now. You can see the counties there. Los Angeles and Santa Barbara County having them in 2 different places. There are many other jurisdictions in discussion, maybe a dozen or so, and then some are also inventing alternatives, which I'll talk about in a minute. But all of these courts are based on that 1170.9 alternative sentencing law that Scott described, although of course they can also utilize other law that's applicable in the cases. Now, the law 1170.9 and 1001.80, the diversion law for veterans accused of misdemeanors, both are worded such that there is considerable judicial discretion granted as to who's going to get in and who's not. Judges have wide discretion in making that decision, setting their criteria if they want to do that. Veterans Treatment Courts within will always set eligibility criteria that go beyond just the legal requirements of the law. But there's a considerable wide variation, and I thought what I'd do is give you a picture here of just some of the things that are being done. I do not mean to say that there's any one court that actually uses all of these exclusion criteria, for instance. A common way of setting criteria is to say, well, certain offenses are excluded, having received a conviction for that offense and then being placed on probation and sent over here. Violent and serious felonies are often on that list. Those are 2 different sections of the penal code. Sometimes a Veterans Treatment Court team will decide if the offense resulted in death, great bodily injury, or disability, we will disallow that veteran from coming in. Arson is very commonly disallowed. Unfortunately, DUI, at least to some degree, is disallowed in many cases. Strike-eligible crimes. Sex offenders are usually disallowed, same with documented gang members. And then finally, there is this one about being a danger or substantial risk to the society that's used sometimes as kind of a catch-all if they're worried about the risk of a particular veteran being out walking the streets. Veterans Treatment Courts also set criteria other than just having to do with the offense, and we tend to call them suitability criteria. Some will require VA eligibility, that is eligibility for VA health care, so that all of the veterans in the court then can receive their health care, their mental health therapy from the VA and not from other parties. I'd sure prefer that counties didn't do that because there are many, many other resources to go to in order to be able to construct treatment plans for those ineligible for VA health care. Some require county residence, and you can understand why, and some require combat experience. That's pretty much a throwback to the way the law used to be up to until it was changed 5 years ago. And there are, as Scott mentioned, there are lots of reasons why the word combat can be misleading in a lot of ways, and setting your court without the use of that word works really well. A Veterans Treatment Court consists of a 10-person team. In fact, it's these 10 people that Justice for Vets will require that you send to one of their 3-day training programs. In addition to the judge, we have a representative of the public defender and of the district attorney. There needs to be a team coordinator who's handling all the data surrounding eligibility for making a decision as to whether someone will be admitted to the court, or all the data about is this veteran who's appearing in court today, or has that veteran done all the things that it was required to do by the court in the last appearance, like go to a certain housing place, go to certain therapy appointments, certain probation appointments, certain drug and alcohol tests, etc. There ought to be a probation officer assigned to the court. They're actually pretty busy, as I've noticed, in court, and especially in the staffing meetings that happen before court. Law enforcement should be represented in this team, but oftentimes they won't actually be present there at the staffing meetings, but having somebody at jail inmate services helps an awful lot in the team being able to get its job done, especially in trying to capture data about whether a particular veteran is or is not eligible and being able to grab them when they need them. A key individual, the busiest person on that team, is going to be this Veterans Justice Outreach Specialist of the VA, who will be creating the treatment plans for the veterans and then managing those plans, changing housing, changing modes of therapy when it's called for, and keeping track of whether that's going well or not and reporting back to the team. There should be somebody from your county mental health department there, and I understand there are a lot of such folks welcome on this call today. County mental health departments can be very useful in conducting assessments for eligibility of those who are in custody and in creating treatment plans for those who are ineligible for VA health care. Finally, you have to have this peer mentoring organization. I'll talk some more about that later, but I also described it a few slides ago. And then you really ought to have a court analyst or evaluator who's keeping track of the data as it flows through the court so that reports can be presented and prepared, and that way the Veterans Treatment Court team can self-assess once a year or so how well they're doing, can provide the data elsewhere, and of course if you have data, it's possible, much more likely that you'll be able to get a government grant to fund some of your operations than if you didn't have data. Veterans Treatment Courts are very efficient, and the key to that is this team. It's the same group of people who show up once a month or twice a month to these staffing meetings to discuss each of the cases, to discuss the applicants and whether they should be admitted. And these people, when working together and watching all these treatment plans come about, become very good with their veteran-related knowledge. They get to know each other really well. They get to work fast together. I was just in San Francisco where we went through probably 30 cases in about 1 hour in the judge's office, and boy, were they moving fast. The team gathers really only during court and during pre-court staffing. Other than that, the exchange of information is by email and stuff. So they're really not being bothered and to have to put in too many hours to do this job. And maybe most importantly, they develop expertise in dealing with these military-specific mental health problems so that they will be able to contribute in putting together that treatment plan and understanding and evaluating how each of the veterans is doing. Now this team, though, should also be supplemented by other veterans-related resources. The VA can't do everything for you. There are going to be other people who can provide housing, other people who can provide trauma-informed therapy. There are some really great nonprofits around California who are doing pro bono therapy for troubled veterans, for instance. Employment. Did you know that your local employment development department, that's the State Department, the local office in your county has at least one veteran specialist, and larger counties will have maybe up to half a dozen of them. Education. A lot of universities have special means of admission for veterans and provide special services for veterans. And it's good to know them because some of the people going through Veterans Treatment Court, of course, are going to want to further their education, and maybe that's the best plan for them moving on from this criminal justice experience. And finally, entitlements. You've got to have links to the Veterans Benefit Administration for those benefits, and also to the Social Security Administration and maybe others. We are in an era of limited resources, and believe me, as I travel around California trying to get these courts started, I run into this quite a bit because the courts have not been immune. In fact, they've been hit pretty darn hard in the budget cuts of the recent recession. So consequently, in order to create a veterans treatment court, sometimes you might rely on volunteer labor. I've seen, well, first of all, there are the peer mentoring programs. They are basically all volunteer. There have been places in the country where I think the court actually paid someone to be the coordinator of a peer mentoring program, but I know of none of those in California. And so the coordinators and then, of course, all the mentors are themselves volunteers. I've known places where the coordinator was a volunteer, places where the court analyst was a volunteer. Heck, I did that 1 year myself for the newly started court in Alameda County. I've even known counties where their budget situation was so bad they had volunteer probation officers, and one of them showed up as the officer in a veterans treatment court. And they have volunteers doing case management, perhaps psychologists or counselors from the local community. They use shared labor also in order to save money. One thing you can do is use personnel from existing courts. You can take the mental health court team, just add a little bit of time on to the end of that mental health court calendar, create for your veterans treatment court calendar, and the team seamlessly moves from one set of clients to another set of clients. And that's a very efficient way of getting things done without having to go out and bother the district attorney, public defender, etc., for additional people to staff a veterans treatment court. A good best practice in veterans treatment courts is to provide case management, and what you will find is that housing and therapy providers will often provide case management themselves. The VA does some of that, but almost every housing provider that is contracted by the VA will in fact have case management, and that way you'll have somebody following that veteran and rendering reports as to how well the veteran's doing, so you can track what's going on. Large veterans organizations can be a real help. I found them to be very helpful in these two things listed on the slide. One is transportation, which is a real issue. A lot of the veterans are going to be indigent. A lot of them will be homeless, not have automobiles, and they can't get to court, they can't get to work, they can't get to their appointments. And so veterans organizations will often step up to the plate and provide transportation for these people. Another good thing that veterans organizations can do, they can provide small amounts of money to a slush fund that I'd recommend every veterans treatment court have, and they can do things like buy those Starbucks cards, buy bus tokens, and maybe some incentives to be given to people, and things of that nature that take a little bit of money to accomplish. Finally, you can look to other nonprofits for housing, as I mentioned before, employment, trauma-informed therapy, things of that nature. Now, I mentioned that there were alternatives to veterans treatment courts in smaller counties, and here are 3 examples. One way of doing it is to direct your veteran defendants to a specific judge who understands 1170.9 and has been through it a few times with some other defendants. But for that, you need a champion, and you really need the involvement of the local VA to do the prepare the treatment plans, perform the assessments, and things of that nature. Sonoma County did that pretty successfully in the past, but it depends on that champion, and in this case, that person in Sonoma County changed jobs, and the program pretty much disappeared. And the second bullet, you can implement it via an existing drug court or a mental health court where there might actually be a team of people there, but you don't make it a full veterans treatment court calendar, and I've seen that done pretty successfully. It's underway now in Amador County. Thirdly, this champion can select eligible veteran defendants having met them in county jail or wherever that seem to be eligible for PC 1170.9 sentencing, and then bring them into any courtroom, and the attorneys there decide whether alternative sentencing should be suggested to the judge and whether that would be appropriate in that case. Again, you probably need the involvement of the local VA in that case as well. One thing I should point out about all these alternatives is they all pretty much require the heavy involvement of some champion, and if that champion moves out of town or changes jobs or whatever it is, you may lose that whole program. So it's far better to go ahead and create that more formal veterans treatment court calendar that I've described here in order to best serve the veterans and to find all of them. That champion is never going to find all of them all by himself or herself. Okay, you might be interested in how do we go about getting veterans treatment courts started here in the county where I live. Well, here's what I recommend. I recommend that the first thing you do is start identifying veterans at county jail. And why is that? Well, as Scott mentioned, that's one way of us finding out, us being criminal justice, finding out who the veterans are. Unfortunately, I've also found that the communication mechanism from the people at county jail back out to the district attorney or public defender is really lacking in just about every county. And so the fact that they get identified at county jail oftentimes isn't much of a step in the direction of getting them into the alternative justice that they might be eligible for. But a really good thing about identifying veterans at county jail is you can collect data there. You can count the number of veterans who self-identified over a period, divide that by all the people who were booked in county jail during that same period, and come up with the percentages such as Megan showed in that slide earlier in our webinar. And that goes a long way towards convincing the presiding judge, the board of supervisors, the district attorney, and other people who would very legitimately ask, how big is the need here? I don't really know if we need to go through with this or not. All right, secondly, there are lots and lots of legal issues, very legal issues, involved in creating a veterans treatment court and in running it. And it's best for the district attorney, public defender, and the judge to sit down and talk their way through those things prior to establishing the court and prior to taking this larger team of people through the drill of putting together a protocol. They need to talk about defendant eligibility, especially as it applies to offenses. This will largely boil down to, as you might imagine, a negotiation between the prosecutor and the defender, with the judge mediating in that negotiation and getting to whatever conclusion they're going to arrive at. And what will come out of that is a set of eligibility criteria that I've seen now such sets in about a dozen different places, and they vary quite a bit. The next thing I would recommend is to have a series of meetings to plan how the court is going to operate. Okay, so we found out who the person is a veteran, and the attorney wants to apply to Veterans Treatment Court. To whom does the attorney apply? And how do you find out whether this person is in fact a veteran, as he claims to be? How do you determine whether this person has a mental health problem that would be eligible? How do you determine if that mental health problem appears to be related to military service? You have to have a protocol for each of those steps in order to be efficient in operating a Veterans Treatment Court. In order to have these meetings, you need to identify that core team of up to 10 as soon as you can, and make sure that all those folks are in these meetings discussing these subjects, so they'll have buy-in when you have the protocol all put together. Another thing you need to do then, having completed these meetings and being pretty much ready to launch your Veterans Treatment Court, is to identify and then to educate all of these other local resources, the EDD person I talked about, the Social Security person, the nonprofit mental health provider, the housing provider, all these folks. Bring them into a room, let the judge stand up and tell them, this is what we're doing and this is why, and we're excited about doing it, and we want you to be part of our team. And then get the discussion going in the room and get those people signed on to help your Veterans Treatment Court. Having done all that, you're ready to begin, and typically, not typically actually, what could be done in theory is to assemble this kind of a plan and present it to the presiding judge for approval. What I'm finding is it's much more likely that the presiding judge has been informed by the judge who wants to start this court all along and is following along and is in favor of getting this thing started. And my computer is hiccuping on me. How am I doing here? Okay. Next, assemble that cadre of peer mentors before you actually start your Veterans Treatment Court. So the first people who come in there for those first court appearances will be paired up by the judge in that first court appearance with their unique mentor. And finally, I do recommend that these teams attend their Justice for Vets training. It doesn't have to be before you start your court. In fact, there is an argument that it's a good idea to wait until after you've started your court so that you have some real-life experience upon which to base the questions. All right, and this is the end of my presentation, and I'm going to pass it over to the moderator.
Thank you, Duncan. And thank you to all the presenters today. Now we'd like to open up a discussion with the audience. If you have any questions, please feel free to ask them via the question or chat box on the right side of the screen. And we'll do our best to go through them all. If you've asked a question at any time during the training, we'll address those now as well. So we're going to start with you, Megan. Of the 2004 data reported, the question here is, of the 2004 data reported, what percentage is attributed to Gulf War I participants?
That's a very good question. So I did state that Vietnam-era veterans were the largest group of wartime service veterans that were accounted for in 2004. But the percentage of veterans reporting service during the Persian Gulf War era, which they counted as 1990 to 1991 at the time, they say is stable in state prisons. So they say 14% in 2004 and 12% in 1997. But interestingly, in federal prison, those numbers grew from 13% to 21% of veterans in federal prison over that period of 1997 to 2004. And then just to go over other eras, service during either World War II or the Korean conflict was reported 2% of state and 3% of federal prison veterans in 2004. And fewer than 5% at the time in 2004 were Iraq or Afghanistan era. And I can email that document. I know someone had asked about some of the other citations that I went over that were not in the slide, so I can email that document out. I think what we're going to do is do a resource document as a follow-up to all of the the attendees, so I can send a link to that document out in the resource document.
Thank you, Megan. Scott, we have a question for you here. Anecdotally, I've heard that 1170.9 is not really being used outside of veterans treatment courts. How can counties learn more about this diversionary law who are not located next to veteran treatment courts?
Quite simply, it takes an attorney filing a petition. If the person is, or the defendant is standing there and there is not a veterans treatment court built up in that location, then the person should be filing a petition to get this kind of relief. I've had a number of instances where even if the district attorney's office, because we've talked about it as a collaborative court, meaning people have to agree to put the person in, then you can go and you can litigate whether or not they would still qualify for these requirements and have the same requirements, and require and litigate whether or not that they can still get the relief. It's harder when I think there are courts existing, because the judge isn't likely going to want to do the work of supervising that person if they have an option to send them to Veterans Treatment Court. But sometimes just filing the petition causes that judge to call the other judge and go, well, what's the deal here? Why not this guy? Well, you know, he's in front of me, I'm reading the paperwork, and it sounds good to me. Why are they saying no? And at least it gets the conversation going, and then we can start arguing about the person. I think that what is equally important to discuss out of this model is that a number of the smaller counties have a disproportionate number of veterans to general population. If you're talking about rural counties, that many of them have a greater number of veterans because some veterans don't want to come back to cities. They want to come back to places where they can feel some space, especially those that did urban combat in Iraq. I've been looking and more moving to rural counties. We had a Plymouth County try to start up a veterans treatment court because they realized they had a greater disproportionate number of veterans and they weren't getting the treatment and the services that they wanted. So they realized they had a need and started to try to build one, but they're only going to have 4 or 5 people. It's hard to build camaraderie amongst the Corps when you've got 4 or 5 people, but it's still possible. And what I suggest is that you file an 1170.9 petition, but you also file with it a treatment plan to show a judge, hey, look, this will be manageable because we're going to have the person do this, this, and that. So it's almost like you have to have all of your ducks in a row before you can present your request to have the person receive alternative sentencing. I hope that answers your question.
Thank you, Scott. Duncan, we have a question for you. The question is, you stated DUI, domestic violence, and firearms are the 3 charges treatment courts should focus on. So, how do veteran treatment courts handle domestic violence charges? And then, as an extension of that question, how has this approach to allowing domestic violence charges changed over the years through veteran treatment court spheres?
That's a real good question, and there's lots of different answers to that question around the state. Let's see. As to how domestic violence cases are handled by veterans treatment courts, they're generally done in I can think of 3 ways. One is, in at least one county, the judge who runs the veterans treatment court has a deal made with the judge who runs the domestic violence court in that same county, and they jointly supervise this veteran, and the DV portion of the rehabilitation takes place in that DV court. Secondly, a veterans treatment court can choose to supervise the veteran using the DV resources that are available and typically used in that county for those kinds of offenses, and there is a mandated 52-week domestic violence rehabilitative program in California with considerable requirements to be certified by your local probation department. A third very interesting way, however, that I think addresses the problem much better for veterans specifically, since they are known not to respond very well to your typical domestic violence rehab. They are oftentimes not your typical domestic violence perpetrator, but rather someone who returned from military service, had a real big problem reintegrating, and the first place that that problem showed up was the intimacy of the home. That happens quite a bit, unfortunately. Anyway, this third way of dealing with it is for the court to set up a special domestic violence rehabilitation program for veterans only within that jurisdiction and use that special program. That's been very successfully done 4 times in LA, once in San Diego, once in San Francisco County, and other counties are working on developing these special programs. To me, that's the best way to do it, because veteran-specific programs are very, very helpful in a really tough problem such as rehabilitation from domestic violence.
Thank you, Duncan. Scott, we have another question for you. What is the impact of veterans utilizing 1001.80 without having to establish nexus? Are there mostly theft crimes, et cetera, that apply here? Homeless populations, et cetera? Are there any negative impacts on not establishing nexus?
Well, in order for a judge to feel like to grant the requirements, they have to feel like the person's issue is going to be addressed. And this is where I said that even though they didn't write a nexus in it, most judges are almost requiring a nexus, because a judge has to be able to say, hey, I gave them a treatment program which is going to make them less likely to commit the crime in the future. So that's an interesting problem when you're saying, well, there's no connection to the crime as to the treatment. Well, no. Judges aren't going to feel pretty comfortable with that, because remember, they have to say that this person is less likely to go out and commit another crime because we diverted them. If there's not that double connection, then it makes it harder for it. Where it comes to work, and what I have seen a couple of times, is an argument can be made that the PTSD for the person caused them to have these other problems, isolation and other kinds of things, and the theft or money motivated activity is simply a way of attempting to keep that level of isolation, and by dealing with the isolation and these other kinds of things, we can take off that risky spending behavior, which is leading to the theft kind of behavior anyways. And so I try to make that connection, even though there's not a true double connection there. It just adds an extra little step in there and say, look, if we still deal with this PTSD, we're going to be able to reduce dangerous behaviors like spending behaviors, which is just a form of self-punishment in some ways too. And then that can help us get the person into a diversion style program. We've also had one that he had the theft of a shopping cart was the hang-up. You know, I know that sounds ridiculous to some counties, but that was actually the charged crime. He was found with drugs and in possession of a stolen shopping cart. He was homeless, and that made him statutory ineligible for a lot of other programs. And I said, but the military diversion law doesn't have any of those requirements. It is more inclusive. So he can still take his theft of shopping cart and his possession of drugs, and both of those charges can be diverted rather than using the regular drug diversion laws. Go ahead, Tim.
Thank you, Scott. So Duncan, we have another question for you. How do veteran treatment courts focus on a reduction of collateral consequences, that is, expungement of records, etc.?
Yeah, it's done in several ways. First of all, of course, Scott described the remarkable incentives built into 1170.9 by legislation of a couple of years ago. So veterans now have a lot more going for them in their favor. However, there always is the question of how solid is this expungement. And judges are now filing separate orders for the sealing of arrest records and for the sealing of various records to ensure that this expungement on steroids that's available through 1170.9 does in fact work for the benefit of the veteran, and they don't have these collateral consequences that have been falling out, of course, for so many people in the criminal justice system.
Thank you, Duncan. And as a follow-up to that, I have another question here for you. What grants are typically available for jurisdictions to establish vet courts?
Okay, yeah. I found 3 different kinds of grants that are available for this kind of a court. First of all, there are 2 flavors that come down from the federal government. Both of them, I believe, originally from the Department of Justice and then coming down through Health and Human Services or through nonprofits. A third one, though, is interestingly, the Judicial Council here in California has received money from the state legislature in recent years and have created some of their own grant programs now for the improvement of recidivism programs, and Veterans Treatment Court can qualify there for the improvement of collaborative courts, and a Veterans Treatment Program can qualify there. So I encourage my clients to find all 3 of these kinds of grants that might be available to them. And for anybody who's listening right now, there will soon be the annual announcement of the big one for helping start new Veterans Treatment Courts, that money that comes down from the Department of Justice.
Thank you, Duncan. Scott, we have a question for you. The question is, how is nexus established between the service-connected injury and the crime when applying 1170.9? What or who does the assessment?
Right now, what we do, and this is not scientific, is we have the person's medical records, mental health records. We take and cut and paste pieces of them, and then I submit what I can put together as the best argument for a connection between the crime, their service, their time. It makes it easy when it's a crime directly connected to symptomology of PTSD, when it's that's easy. It's harder when we're talking about traumatic brain injuries sometimes, because I have to be able to do that walkthrough of saying they have a traumatic brain injury which causes them to have cognitive deficits and make bad decisions about this. It's harder yet when you're talking about impulse control as maybe part of the reason why they're having trouble. We had a guy who broke into a neighbor's, he was unfortunately using methamphetamine, so let's get that out. He was a meth user at the time, but he broke into another person's hotel room in the same kind of Fleabag Scuzz motel that he and this other person were staying, because that other person was also using methamphetamine, and he didn't steal it to try to use it. He was actually breaking in because that person had children, and I had to kind of explain the archetype of where he was as this kind of thinking he was protecting the children was in part because he had poor impulse control, and he thought, oh my God, those children are going to see our people use meth, and had to go through and present up facts about how he had done this work to try to use his drugs not around his own children. That's one of the reasons why he had problems within his marriage. And so you have to kind of massage the facts in such a way, then present the argument about that the reason why he did the taking was because he had poor impulse control and had a thought process that was diluted because of the traumatic brain injury. He wasn't able to cognitively think through, no, that person shouldn't be doing drugs around their kids. So that you could then write that all up and say, look, this is all part and parcel of the fact that he has a traumatic brain injury from his service. We know when he was injured during the service, when he was on guard duty, covering an entrance to a small mobile phone installation, and a small explosive device went off. It can help us prove up that element. But largely, it comes from a collaboration between the Veterans Justice Outreach Specialist, who can pull and draft the records, give me an opportunity to present those best arguments to the district attorney first to see if they're in agreement, and then, if necessary, to litigate it if they're not in agreement. Go ahead, Tim.
Thank you, Scott. One more question for you. It's the last question here. The question is, so how do Penal Codes 1170.9 and 1001.80 compare with other states? How, or have other states enacted similar diversionary laws?
The diversionary law is more unique. The granddaddy of them all, the 1170.9 that creates the Veterans Treatment Court, that one is much more typical. Every state has a slightly different version of it, but lots of states have the same kind of laws out there that in one form or another that still has the same kind of requirements. Many states still also require combat service, so there's some variability in that, but a lot of them have created some statement about alternative sentencing, including suspension of jail time or otherwise, for a veterans treatment process. Go ahead, Tim.
Okay, well, thank you very much, Scott, and thank you to all of our presenters as well as you, our listeners. This concludes our presentation. Please note that each of you will receive an email in about an hour asking you to complete a brief survey to evaluate this presentation. Your feedback is important to us, and it's greatly appreciated. Those of you seeking continuing education units or certificates of completion will need to complete this information in order to receive credit for participating in the training. We're going to archive this presentation on our YouTube channel. If you want to visit it, it's youtube.com/vetshelpingvets. Please subscribe to it, and you will be notified once the presentation is uploaded. So we're going to upload this presentation in a few days and send you a copy of the PowerPoint presentation as well. Thank you again for your time. This concludes our training.